this is Amy Pittman, one of the attorneys here at Pittman Law Office. And this is part one of 2 videos that we're going to do on the basics of estate planning. And today we're going to talk about what happens when you pass away, which tends to be what everybody kind of thinks of first when they think about estate planning. So how are your assets going to pass when you die? It will depend on how those assets are titled. So if the assets are in my name alone, Amy Pittman, and I do not have a beneficiary on the account, then that's going to go to probate. So any asset that's in my name alone that does not have a beneficiary, or maybe I don't have another owner on the account, is going to go to probate. Well, what's probate? Probate is a process of unfreezing an asset that's in a deceased person's name alone. Okay, so your last will and testament does not avoid probate. Your last will and testament, you'll see here, is going to only come into effect when you die and if there's an asset in your name alone. And that last will and testament is going to allow you ahead of time to name who your beneficiaries are and then who you want to be named as the personal representative. That's the same thing as the executor. So we only have a will, last will and testament, coming into play when someone dies, the asset does not have a beneficiary or another owner. So this could be different in every state as far as what the probate process is going to look like. You know, there could be minimums set for the value of the assets, but we're talking about Florida law. It's the only state I'm worried about because that's the only state I'm licensed to practice in and the only state I'm giving guidance to my clients. So in Florida, we have several levels of probate. If the asset is under $75,000, we can do a summary administration, which tends to be a pretty quick 90-day process. If it's over $75,000, the asset itself that's in the deceased person's name alone, and that's a formal administration, which can take 6 months to a year. But again, the last will and testament is only covering those assets that person did not name a beneficiary. So if I have an account that says Amy Pittman, pay on death Josh Pittman, when I die, Josh must go into the bank with my death certificate or contact that financial company and say, hey, Amy's passed away, I'm the beneficiary. So that means you really need to have a list of all of your assets, identify how they are owned, and then confirm that you have the correct beneficiaries on the account. And that's if you're going to do a last will and testament, what we call a will-based plan. And then I have clients that create a revocable trust, and you'll see here that we're talking about the same idea of how the assets go when you die. So if I create a revocable trust, I'm the trust maker. Some people will call that a settlor, grantor, but I own that trust. This is not an irrevocable trust. And what I'm trying to do is the same thing in my will. I'm identifying beneficiaries, but I still own the assets that I title in my trust, just like I own them today. So I can still deplete, I can still use the assets, I can put my house in the trust and then take the house out of the trust. I can amend it. I can change who my beneficiaries are, just like I can amend my will. But the idea with why most people are doing a trust is so that they can get their assets, typically what we call non-qualified assets. So my bank accounts, checking, savings, stocks, bonds, brokerage accounts, life insurance proceeds, real estate, non-qualified annuities. I'm going to go to those companies and say, hey, this is Amy Pittman's trust. Name Amy Pittman's trust as the owner or the beneficiary of those assets. So then those assets, when I die, are going to be in Amy Pittman's trust. It's going to be all in this bucket, and my trust will say, okay, equally to my 2 kids. Who's in charge of that trust is called a successor trustee. Because while I'm alive, I'm typically going to be the trustee unless I'm incapacitated. So you're not losing control, you're just trying to do some of the work ahead of time, so it's less administration process. Definitely not going to go through probate if you fund your trust properly. So when we talk about funding, again, clients think they come in and do a trust and then that's all they need to do. Well, you have to go to the banks. You're going to have to tell the financial institution, hey, I have a trust, in order for your brokerage account to get titled in the trust. If you buy a house, you have to tell the realtor ahead of time, hey, I want to make sure this house goes on my trust. If I have a business and I want to put my business interest in the trust, I'm going to have to do paperwork. I'm going to have to make sure that the ownership is connected to the trust. And again, with the trust, you're going to be able to say how those assets go when you die. While you're alive, they're your assets. You're the beneficiary of your trust while you're alive. But when you die, you can say, okay, well, my children are minors, so I want to control it until they reach a certain age. If they're bad with money, I can say they need to get it over a certain period of time. Usually that's called a general needs trust. If one of my beneficiaries is on governmental assistance and I don't want them to get kicked off of that assistance, so I'm going to do a special needs trust. Or maybe I'm just going to retain the assets for a period because I'm married to someone who's not the parent of my children, but I want to provide for them over a certain period of time. So you'll have people do trust for that, trying to maintain control over the beneficiary's inheritance. Or maybe your child's spouse, you're concerned with divorce, or you don't care for the person's spouse, that's your child's spouse. So you're going to try to control it so it's less money going to them all at once. But again, when you have a revocable trust, it's a document that then you have to fund, meaning you have to go to the financial institutions. And it's going to be different for everybody. You can't listen to your neighbors or friends saying, oh, this is what I need to put in my trust. Because again, your situation may be different. And that's really why we stress that you hire an attorney, an estate planning attorney, someone that's doing estate planning to help you with creating the revocable trust or funding the trust. Again, we can provide you instructions, but I'm not the one that can go to the bank and put it in the trust for you. Now, if it's a piece of property in Florida, we can handle that, but we're not going to be able to put your property that's in Michigan or Georgia in this trust. You would have to hire an attorney in that state. And whether you have a trust or a will, we're going to always tell you to create a list of all of your assets, making sure that those accounts are listed and it shows who the owner is. Right? Is it Amy Pittman or is it Amy Pittman's trust? If I don't have a trust, it's my name. Who are the beneficiaries? So again, we really want to make sure that you're organized, have that list of assets, also have a list of your expenses. How do you pay those expenses, passwords, anything that's going to make it easier for your loved ones when you pass away or become incapacitated. Now, the other thing with the revocable trust is you will also have a will. So let's say you pass away and you totally flaked, you forgot to put your bank account in the trust. Well, that account, because it was just in your name, you're deceased, there's no beneficiaries on the account, that account's still going to go through probate. And with a trust, we don't submit the trust to the probate court. We're going to submit the will. And most people refer to it as a pour-over will, but it's still a regular last will and testament. The difference is you're not going to see your named individual beneficiaries. You're going to see the trust as the beneficiary, and that's called a pour-over will. So in the event I die and there's an asset just in Amy Pittman's name, that's frozen. Because again, the only place that can unfreeze an asset that's in a deceased person's name is a probate court. And that way they're making sure that it's going to the right people, the people that I've said in my estate planning document, my will. So that asset goes through the probate process and then gets poured into the trust. And that cost and time is still going to be there, and it will be based on the value of the asset that's going through a probate. So we stress all the time to clients, you have to be very intentional about your planning. So how you title your assets. Are you titling it in your name with beneficiaries? Don't name the person that you're naming as the executor or personal representative as the beneficiary, because if I say, oh, I'm going to name my daughter as the beneficiary of my bank account and she'll make sure she gives part of it to her brother, that's not going to necessarily happen. So don't just name the person that you think is going to be in charge as your beneficiary, because they would use that money for themselves. They do not have to use it for your estate. And again, we as attorneys will go through your particular situation to see if you should do a will versus a trust. Not everybody needs a trust. It depends on the type of assets they have, their family dynamics, the type of beneficiaries, how many beneficiaries, how they want those assets to go to their beneficiaries. So again, that's where having a conversation with an estate planning attorney is going to allow the attorney to kind of figure out what's best for you. Again, when you talk about passing, it's all based on the type of assets you have, who those beneficiaries are. So make sure that it's intentional, that you're naming the correct people in charge as well as beneficiaries in your will or your trust, or if you're doing beneficiary designations. Because again, there's certain assets like IRAs, 401ks, that you can name direct beneficiaries, and those beneficiaries are going to receive it. And it'll bypass the will or the trust. And this is part 1, talking about basics of estate planning, revocable trust, and the last will and testament. And you'll check out our next video, which is going to be about our incapacity planning. Hope that helps. And again, that's estate planning the pink way.